Once again, good afternoon, everyone. So, to talk about today's topic, I welcome our distinguished expert, CA Arvind Tangam, who has appeared before GSTAT and previous erstwhile regime tribunals, and he has a very good expertise in handling the litigation related to other laws in service tax and also in GST up to tribunal level. So he will be taking us through the procedural aspects, which has been notified through a recent notification today. So over to you, sir.
So a very good afternoon, everyone. At the outset, it is extremely a pleasure to welcome you all to the 73rd session of Zen Tax Talks. So when Jay Mohan told me that it is a case of the GST Appellate Tribunal, GSTAT, I was under the impression that the GST Appellate Tribunal had got formed, and therefore I came prepared for a case towards the GST Appellate Tribunal. And then he said it is going to be a very pleasant surprise that we have to address our members of Zen Tax Talks on this topic, on the latest notification which has notified the GST Appellate Tribunal Procedure Rules 2025. So here we are at the 73rd session discussing about the latest procedures that have been notified with respect to the GST Appellate Tribunal. Right. So to get started with, right. So with respect to the GST Appellate Tribunal, what case goes before the GST Appellate Tribunal? We need to understand the various stages of departmental proceedings, and there could be a show cause notice which initiates a departmental proceeding, and further to a show cause notice, it would result in what is called as an adjudication order, right? So the adjudication order, that is the demand of tax cum recovery notice, which is the order in DRC 07 plus a detailed or a special order, is being issued, against which the first appeal would be to the department under the provisions of section 107 before the Deputy Commissioner appeals or the Joint Commissioner appeals or the Additional Commissioner appeals or the Commissioner appeals, as the case may be, which is the first appeal as provided for under the CGST Act under section 107. The second appeal is under the provisions of section 112 of the CGST Act before the GST Appellate Tribunal, for which the procedure rules have been notified under section 111. The appeal to the GST Tribunal is under the provisions of section 112. The procedure thereon has been notified under the provisions of section 111. The significance of the section 112 and section 111 I would detail during the presentation today. And is this the last remedy with respect to the various proceedings under the GST law? No. After the appeal of the GST Appellate Tribunal, either the appellant, which is the taxpayer, or the respondent in the form of the department, or either way, which is the department or the taxpayer, can proceed to the High Court or Supreme Court only and only if it is a question of law, or even to qualify that word to say it should be a substantial question of law, or it involves violation of the principles of natural justice, in which situation, even before going through the rigors of section 107 and 112, you may directly, with respect to the proceedings of an order, you may go to the High Court or Supreme Court whenever there is a gross violation of the principles of natural justice. So why at all do we have to think about the significance of High Court and Supreme Court when we are talking about the second appeal, which is before the GST Tribunal, is for the reason that an appeal before the High Court or Supreme Court would be admissible only when there is a substantial question of law. This brings to rest and this brings substantial clarity that the GST Appellate Tribunal, to whom we are filing an appeal under the provisions of section 112, the appeal being notified, the procedure being notified under the provisions of section 111, is the ultimate fact-finding authority. If there is any dispute on the facts, the ultimate fact-finding authority is the GST Appellate Tribunal, and the High Court or the Supreme Court will not come into a matter involving questioning facts. there will only be a question of substantial question of law before the High Court or Supreme Court, and therefore the GST Appellate Tribunal has enormous significance. And after a long wait since the inception of GST in 2017, in 2025, now we are almost nearing the reality that the GST Appellate Tribunal will be constituted at various designated places. So this GST Appellate Tribunal, which is yet to be constituted in its full form, now we have the latest provisions which has notified the procedures that will govern the GST Appellate Tribunal, which has been notified under section 111. So with respect to GST Appellate Tribunal, is there only one section? Is there only one rule that we are going to discuss about that we need to really decipher? Or are there multiple provisions under the provisions of the GSTAT and the rules thereunder which needs to be understood? With respect to the GST Appellate Tribunal, the legal provisions contained in section 109 to 116 become completely relevant. So 109 dealing with the constitution of the Appellate Tribunal and the benches thereof, the constitution and the appointment with respect to the Appellate Tribunal have been the subject matter of dispute for a very long time. And after the requisite amendments, today it is going to see the light of the day. The procedure before the Appellate Tribunal under the provisions of section 111, under which the rules have been notified now in April 2025. Then the appeal to the Appellate Tribunal, the legal provision contained in section 112, the order of the Appellate Tribunal contained in section 113, the financial and administrative powers, a single line section contained in section 114, and then a couple of sections with respect to interest on refund of amount, and 116 talking about the appearance by an authorized representative. When I am going to talk about the procedure rules in detail, why are we discussing about all these sections today? It is to bring to the members of our august audience that the notified rules are only and only in respect of section 111. And other legal provisions contained in section 112, say for example 113, say for example 116, will continue to be governed under the provisions of the said section and will not be governed by the provisions of the notified rules. Because the Act will have an overriding power over the rules, and the rules are notified only under the provisions of section 111 and not under the entire ambit of the GST Act or the entire ambit of section 109 to 116. The rules, as we would read, the opening paragraph very clearly stipulate that it is covered under the provisions that it is issued only on the basis of section 111 of the GST Act. With respect to the GST rules, we already have the provisions in the CGST rules in rule number 1110 to rule number 114, 5 rules which govern various aspects relating to the GST Appellate Tribunal. In addition to these 5 rules contained in the CGST rules 2017, we have these additional rules in the form of GST Appellate Tribunal procedure rules. So it is to be well noted and understood that the CGST rules continue to operate, and in addition to these 5 rules, we have an additional set of rules in the format of the GST Appellate Tribunal procedure rules notified under the provisions of section 111 of the CGST Act. So I have been emphasizing on that section 111 is the section under which these rules have been notified, and this is how the opening paragraph in the rules read as under: in exercise of the powers conferred by section 111 of the CGST Act, the GST Appellate Tribunal hereby makes the following rules. So important to also note that the GST Appellate Tribunal themselves are making the following rules for regulating the procedure of functioning of the GST Appellate Tribunal. Generally, the board, the Central Board of Indirect Taxes and Customs, makes the rules governing the various legal provisions in the GST Act. Here, it is very important to note under the provisions contained in Rule 111, under the provisions contained in Section 111, the GST Appellate Tribunal makes the following rules. So, can the tribunal by themselves make rules governing them is or are these rules by and large valid? Do they really have the power to notify the rules for themselves? Let us refer to the provisions of section 111, subsection 1, procedure before the appellate tribunal. The appellate tribunal shall not be bound by the procedure laid down in the Code of Civil Procedure. So what we call as the CPC, the Code of Civil Procedure 1908, is not applicable to the appellate tribunal, but shall be guided by the principles of natural justice and subject to other provisions of this Act and the rules made thereunder, that is the CGST Act and the CGST rules. The appellate tribunal shall have the power to regulate its own procedure. Section 111 confers this power to the GST appellate tribunal to regulate its own procedure. Therefore, these rules, which are nothing but the GST appellate tribunal procedure rules 2025, notified in April 2025, have been issued by the GST appellate tribunal themselves for regulating their own procedures. So therefore, it may well also be noted that though the law provides, section 1111 provides for the power, if the subordinate legislation, that is the rules, override any provisions contained in the Act, be it in section 1111 or in any of the sections contained from section 109 to section 116, then only the provisions contained in the CGST Act will provide, because the rules are only subordinate legislation. So in this regard, if you really look into this GST appellate tribunal procedure rules, there are 15 chapters. We have 15 chapters totally containing 124 rules. Starting from rule number 1 to rule number 124, there are 124 rules contained across 15 chapters. The first of the chapter is the heading and the definitions, the preliminary and the definitions portion containing of containing of 2 rules. The second chapter talking about the power and the functions, which encompasses 15 rules. The institution of appeals, that is the practical procedure relating to the filing of appeals, admission of evidences, has been compassed against 20 rules starting from rule number 18 to rule number 37. And we have, with respect to the cost list, we have a separate chapter for hearing of the appeal, the record of proceedings, maintenance of registers by the appellate tribunal, that is by the registrar, inspection of records, appearance of authorized representative, affidavits, discovery, production and return of documents, examination of witnesses and issue of commissions, disposal of cases and pronouncement of orders, electronic filing and processing of appeals and hybrid proceedings and miscellaneous. So in total, across 15 chapters, we have these 124 rules, which are the GST appellate tribunal procedure rules. This being part 1 of this entire topic, we would be covering selected topics out of this GST appellate tribunal procedure rules and discussing the key aspects of things. The remaining provisions would be continued in part 2 of the discussion relating to the GST appellate tribunal rules. So this is a very important topic for the trade, industry and the practicing professionals at large, and therefore we have ensured that there is enough emphasis given for each of the legal provisions, and therefore we have segregated into multiple sessions on the same content. So why at all this entire address of across all the 72 webinars in ZenTax talks? We have been in a very casual attire across all these days, in a formal attire or in our ZenTax t-shirts or in our formal shirts. But today, it has been imperative that I come dressed adequately to cover this topic. for the reason that under the provisions of the GSTAT rules, it talks about Rule 77 very specifically. That is not just one rule which gives an emphasis on the dressing. We will talk about the first rule, talking about Rule 77, professional dress for the authorized representatives. While appearing before the appellate tribunal, the authorized representatives shall wear the same professional dress as prescribed in their code of conduct. So what could be that professional dress which is prescribed in their code of conduct? Being a chartered accountant in practice, I am wearing a blue coat with a blue tie with an emblem of the ICAI logo also as part of it. This is the professional dress provided for the practicing chartered accountants, and that is the professional dress as provided for under Rule 77 of the GSTAT rules. Is it mandatory? Yes. The authorized representatives shall wear. It is compulsory that the person who is appearing before the appellate tribunal shall be dressed as provided for the rules. Not just a single rule, we also have Rule 122 of the GSTAT rules, which talks about dress for the parties. Every authorized representative, other than a relative or a regular employee of a party, shall appear before the appellate tribunal in his professional dress, if any, and if there is no such professional dress, if there is no such dress, that is a professional dress which is given as per the code of conduct, if it is a male, in a close-collared black coat, or in an open-collared black coat with white shirt and a black tie. So therefore, now the audience will be able to appreciate why every person who goes to the GST appellate tribunal is generally dressed in a black coat, in a white shirt and a black tie. Because that is what is warranted and required as per Rule 122 of the GSTAT rules, and even under the erstwhile provisions of the GSTAT, we had very similar provisions. Therefore, it is very important that a person does not walk into the GST appellate tribunal like he walks into the department and in his very professional dress. It is very important that the dressing is as per provided under Rule number 77 of the GSTAT rules or Rule number 122 of the GSTAT rules. In the case of a female, in a black coat over a white saree or any other white dress. It could be a kurta, it could be a chudidar or whatever be the top, or a dress, or even a saree which should only be white, and on top of it, they can have a black coat. So the emphasis of the dressing towards today's session can well be understood by the audience at large, and that is the significance of the session, right? So we wanted to have a very practical feel of how things would really be. So when Jay Mohan called me for the session, for a GST appellate tribunal, would you be coming dressed to your office, or should you be actually visiting the premises of the GST appellate tribunal? Can you appear before the GST appellate tribunal in this dressing, sitting at your office, or would you need to visit the GST appellate tribunal only in person? We will just check about that also in the immediately coming slides. And before that, with respect to a summer season falling between the 15th of April to the 31st of August, the authorized representatives may, optional, when appearing before the bench of the appellate tribunal, dispense with the wearing of a black coat. Only between these dates, the authorized representative may optionally choose not to wear the black coat. But whereas generally it is being followed that every person is dressed adequately when appearing before the GST appellate tribunal, and whatever has been the GSTAT, the Customs, Excise and Service Tax Appellate Tribunal, which Jaimon was also talking about, which we have been very regularly appearing at, not just in Tamil Nadu, even including at Karnataka as well, right? So the halls are air conditioned, and therefore we don't have to be worried that even in a summer season that you have to be sitting in a coat. It's extremely very beautiful experience to appear before the appellate tribunals, and the level of argument that really happens over there, where the departmental representative in the rank of a commissioner or an additional commissioner or a deputy commissioner stands up before the court and also puts forth his views. We will also see maybe in the next presentation in part 2 of the session that the appellate tribunal is an open court. The GST appellate tribunal is an open court and members can be seated, members can view the proceedings on how the argument is being placed by the authorized representative. So it's an open court and the experience is generally is really very fantastic. The level of argument, the way the legal provisions are being articulated, the way the factual submissions are being made to the convincement of the members of the bench, and how the defense arguments are being countered on the spot is a very fantastic experience. And we have always cherished in our experience of having had so many successful appeals before the various appellate tribunals. Appearing before the appellate tribunals has been our core strength. Our partners, including our partner, my senior partner, or my father, CAP Paulton, we have been regularly appearing before the various tribunals and the experience has always been very fantastic. So, coming back to this session and the discussion that whether at all we can sit at the premises of our office and attend an hearing in an online mode. We have Rule 115 of the GSTAT procedure rules, electronic filing and processing of appeals and applications, etc. This Rule 115 has multiple sub-rules. Starts with the non-obstant clause, that is an overriding provisions over all the other provisions. We had 15 chapters. As I already told you, we have 15 chapters in the GST Appellate Tribunal procedure rules. This provision, rule number 115, contained in the 15th chapter, overrides all the provisions contained in chapter number 1 to chapter number 14, except whatever the President generally says. So this provision will have an overriding impact. Then it goes on to say, every appeal or application to be filed before the appellate tribunal shall be uploaded electronically on the GSTAT portal. So therefore, it becomes very clear that the appeal to the tribunal is to be filed online. Is it the same GST portal that we are using for the filing of appeals, the filing of GST returns, the filing of refund applications, gst.gov.in? No, there is a separate portal for GSTAT. So, every appeal or application will be filed before the GST Appellate Tribunal in that specific GSTAT portal. All appeals and applications filed before the Appellate Tribunal shall be scrutinized and processed electronically through the GSTAT portal, and all notices, communications, summons shall be issued electronically and signed in the manner provided on the said portal. So, the communications and the verification of such applications or appeals made and all other communications will also happen only through the GSTAT portal. All replies filed and documents that are or may be required to be presented before the appellate tribunal, either on the directions of the said tribunal or otherwise, shall be signed, verified, and uploaded electronically on GSTAT portal. Say, for example, during the course of the proceedings, the tribunal requires that certain documents are to be furnished. Then even such documents have to be signed, verified, and uploaded only on the electronic GSTAT portal, electronically on the GSTAT portal. All proceedings before the appellate tribunal shall be conducted through the GSTAT portal, and such proceedings shall be recorded on the said portal. So, whatever proceedings that happen, it will always be conducted through the portal and shall be recorded. A summary of the final order passed by the appellate tribunal or any bench thereof in respect of any appeal shall be uploaded in the form specified in the CGST rules for this purpose. So whenever they talk about CGST rules, then you go back to the parent rule, which is the CGST rules. Otherwise, it talks about the GST Appellate Tribunal procedure rules. So, how many of you now feel that the entire process of filing, processing, and appearing before the GST Appellate Tribunal is going to be fully online? How many of you feel? We have read the provisions of Rule 115 of the GST Appellate Tribunal rules. Sub-Rule 1 to Sub-Rule 6 we have detailed. We have read it in detail, clause by clause. And on an understanding of the same, we feel, yes, it is to be completely online, or is there going to be also an offline option? Is it going to be generally offline, or is it going to be generally online? Generally offline or generally online? Let's have a couple of answers, please. Sir, only offline? Sorry, only online? Only online, right? Okay, so we have so many people, everyone answering to say it's online, online, online. In my point of view, I think online, sir. Okay, right? Let's read now what Subrule 7 goes to say. Subrule 5 talked about all proceedings before the Appellate Tribunal shall be conducted through the GSTAT portal. Subrule 7 goes to say all hearings before the Appellate Tribunal may be conducted either in physical mode or upon the permission of the President in the electronic mode. So now we have the legal provision to say that the hearings before the Appellate Tribunal may be conducted, so it is optional, may be conducted either in physical mode or upon the permission of the President in the electronic mode. Now we understand that the hearing is generally physical, and only when the permission is given by the President, it is in electronic mode. This provision in Subrule 7 is in complete contrast to all the provisions contained in Subrule 1 to Subrule 6 of Rule number 115, and therefore we get an idea that generally it is going to be offline in physical mode. But we will have to wait on how things are going to be actually put in place. Fees and pre-deposit. This is also one of the very significant factors that will impact the filing of an appeal under the provisions of Section 112 of the CGST Act before the GST Appellate Tribunal. That is, for the filing of an appeal against the order passed under Section 107, that is 107 is the first appeal against the order of the first appeal. When you have to file an appeal before the GST Appellate Tribunal, there are two things that will come as an important payment. One, which is the pre-deposit to be made, and a mandatory fee. Even with respect to the filing of appeal before the first appellate authority, that is before the Commissioner appeals or the JC appeals or the ADC appeals or the DC appeals, as the case may be, we make a mandatory pre-deposit of 10%. In addition to the pre-deposit made at the time of the first appeal, when we are filing an appeal before the GST Appellate Tribunal, as provided for in Section 112, subsection 8 of Section 112 provides that if at all there is any admitted liability, the liability needs to be paid in full. If there is a disputed liability, then an additional 10% of the tax amount in dispute needs to be paid, subject to a maximum of rupees 20 crores. So there is a mandatory pre-deposit. Initially, at the first appeal, 10%. Now at the second appeal, additional 10% needs to be paid. In addition to the pre-deposit is paid. If the appeal is in your favor, then the pre-deposit will be refunded back, and there are some special provisions also relating to the same. In addition to the pre-deposit, there is also the requirement for the payment of a fee, which is already contained in Rule number 1110, Subrule 5 of the CGST rules. This amount of quantification is not contained under the GST Appellate Tribunal procedure rules. This is contained under the CGST rules, which goes to say an amount of rupees 1,000 for every 1 lakh of the tax amount in the order appealed against. Irrespective of whether it is an admitted liability or a disputed liability, whatever is the amount in the order, for the amount in the order against which the appeal is being made to the GST Appellate Tribunal, you need to make the payment of a fee to the extent of rupees 1,000 for every 1 lakh. A general understanding could be that 1,000 divided by 1 lakh is 1%. But the readings of the CGST rules does not talk about ₹1,000 or part thereof with respect to the payment of tax liability, with respect to the amount in dispute, with respect to the amount in the order of ₹1 lakh or part thereof. No. It talks about very clearly ₹1,000 for every ₹1 lakh. That is to say, if the demand was ₹5 lakhs in the order in original, then the fee would be ₹5,000. If the demand was 6 lakhs, then the fee would be 6,000. If the demand was 5,50,000 rupees, in our opinion, then the fee would be only ₹5,000 because it does not talk about any part of ₹1 lakh. For 5 lakhs, the fee would be 5,000. For a part of ₹50,000, which is a part of ₹1 lakh, in our opinion, there will not be any additional fee. For ₹6 lakhs, then the fee would be ₹6,000, subject to a maximum of ₹25,000. So minimum fee of at least ₹5,000. You need to take a separate demand draft, or you need to make the payment in the GST portal and then submit it along with the application for an appeal before the GST Appellate Tribunal. Not only with respect to the filing of an appeal, for any other application, say for example, continuation of delay, that something which they call it as an interlocutory application, which we will discuss more in the subsequent part of the session, which is the next session. That is, whenever there is any other additional application that is being made, for every application, the fee will be ₹5,000. Right? So for every application, the fee will be ₹5,000. That is a flat fee. Only with respect to an appeal, which is provided for under Rule 1110(5) of the CGST rules, then the fee is based on the amount in the order. So what is the time period within which I need to file an appeal? This time period is provided for in Section 112 of the CGST Act. Section 112 goes to say, which is the provision providing for the filing of an appeal before the GST Appellate Tribunal. Any person aggrieved by an order passed against him under Section 107 or 108 of the CGST or the SCST Act or the UT-GST Act may appeal to the Appellate Tribunal within a period of, may appeal against such order within 3 months. Within 3 months. From the date on which the orders are to be appealed against is communicated to the person. So I got an order, say for example, on the 1st of March, on the 1st of January 2025, 3 months I need to apply within 31st of March 2025. But today the GST Tribunal is not even in force. Then therefore we have a special provision which got introduced from 2024 to say, or the date as may be notified by the government. The government may notify and extend the date since the GST Appellate Tribunal is going to be notified only thereupon. Therefore, from the date on which the GST Appellate Tribunal is to be notified, then you will be having an additional time. But generally, the time limit for filing an appeal before the GST Appellate Tribunal, as is provided under Section 112, is very clear that it is 3 months from the date on which the order in Section 107 or 108 is being communicated to the person to who is preferring an appeal. That is, the appeal can be preferred either by the taxpayer or also by the department, right? Time period for filing an appeal, though we refer to the provisions of Section 112 under the CGST Act, under the GSTAT rules, that is the GSTAT procedure rules, we have Rule 3, which is the starting of the entire rules, where a period is prescribed by the Act, that is the CGST Act, or the rules, or these rules, that is the GSTAT rules, or under any other law, or is fixed by the Appellate Tribunal for doing any act in computing the time. The day from which the said period is to be reckoned shall be excluded. The day from which, that is, what is the starting date, that date shall be excluded. And if the last day, say for example, the last day for filing an appeal happens to be on 26th of January 2025, which is a Republic Day. This is only an online filing. GST Appellate Tribunal might not be working, but still online filing. You can proceed with the online filing. Can that be the stand? No. it very clearly goes to say if the last day expires on a day when the office of the appellate tribunal is closed, that day and any succeeding day or days on which the appellate tribunal remains closed shall also be excluded. Say, for example, the January 26th falls on a Friday. January 26th is a Friday. Next day is a Saturday, and then it is a Sunday. Therefore, the GST Appellate Tribunal is on leave on 26th of January, 27th and 28th. Since it is a continuous holiday of the succeeding days, all these 3 days shall be excluded. And therefore, when they open up Monday, Tuesday, Wednesday, they will still have time. Sorry, they will still, Friday, Saturday, Sunday will be excluded. And on Monday, they can come and file the appeal. They can come and file the appeal. So even in the era of online filing, the GST Appellate Tribunal procedure rules has very clearly taken into account that if the due date falls to be a holiday and every succeeding day is also a holiday, then those days would be excluded from the time period of computing the time limit or the time period within which the appeal needs to be filed before the GST Appellate Tribunal. Right? With dress code. Yes, sir. Online as per dress code. Right? So the power to extend the time. Rule 14 of the GST Appellate Tribunal rules. The Appellate Tribunal may extend the time appointed by these rules or fixed by any order for doing any act or taking any proceeding upon such terms, if any, as the justice of the case may require, and any extension may be ordered, although the application for the same is not made until the expiration of the time appointed or allowed. So the provision goes to say that the Appellate Tribunal may extend the time, whatever is given. Under the provisions of this Rule 14, can the Appellate Tribunal extend the time as is provided under Section 112 of the CGST Act? Section 112, subsection 1, we clearly read that the appeal to the GST Appellate Tribunal has to be filed within a period of 3 months. Taking cognizance of rule number 14 of the GST Appellate Tribunal rules, can the GST Appellate Tribunal extend the time which is provided for under section 112? Yes, no? Yes. Right? So, yes, Murtusa. But the provisions of the GST Appellate Tribunal rules cannot override the provisions of the CGST Act. The rules, the GSTAT rules are a subordinate legislation, and taking the power of Rule 14, they cannot really extend the time limit as is provided for under Section 112 of the CGST Act. These are only a subordinate legislation. This is also, mind you, only under Section 111 of the CGST Act and not under Section 112. So therefore, it cannot be extended. So what is the working hours of the GST Appellate Tribunal? The office of the GST Appellate Tribunal will be open from 9:30 a.m. to 6 p.m. The bench, the Appellate Tribunal will be sitting generally from 10:30 a.m. to 1:30 p.m. and after lunch break of 1 hour from 2:30 p.m. to 4:30 p.m. subject to any order made by the President. And the President is nothing, is none other than the President of the GST Appellate Tribunal, right? And this shall not prevent the Appellate Tribunal to extend its sitting as it deems fit. They can even work after 4:30. That is not restricted, but generally the sitting hours are 10:30 to 1:30, 2:30 to 4:30, and generally the after these hours, there will be the time for drafting of the orders and all other proceedings. Listing of urgent cases, Rule 12 of the GST Appellate Tribunal rules goes to say any matter which is of urgency if it is filed before 12 noon, shall be listed before the appellate tribunal for the next day itself, on the following working day, as long as it is complete in all respects. And in any exceptional situation, even if it is filed before 3 p.m., you may request an urgent listing of this case immediately the next day. This option I don't think is even available for an appeal to be filed before the DC appeals or the Commissioner appeals. But the GST Appellate Tribunal procedure rules very clearly provide that you may request for an urgent listing. You file it today, tomorrow you ask for a listing. To that extent, the GST Appellate Tribunal rules has provided for this possibility also. Power to exempt complaints of rules or procedures, the GST Appellate Tribunal rules, to what extent is it mandatory to be complied with? Can the bench or the tribunal show some relaxation? The Appellate Tribunal may, on sufficient cause being shown, exempt the parties from complaints with any requirement of these rules, and may give such directions in matters of practice and procedure as it may consider just and expedient on the application moved in this behalf to render substantial justice. Say, for example, I did not wear a coat as was required under the provisions of the GST Tribunal rules. Then I need to move an application stating that I have not complied with, there are sufficient cause, and therefore exempt me from this complaints of this requirement. And based on consideration of such an application, I may be allowed to argue even without complaints of all the rules and procedures as is provided here and there. Why do I talk about it here itself now? That there are many legal provisions which goes to say how a set needs to be presented, how it needs to be printed. Though all these provisions are provided, the GST Appellate Tribunal may, on sufficient cause being shown, if there is a genuine reason why you could not comply with the provisions of these procedures or the rules thereunder, then they may show an exemption. Next, on a very practical side, the question that would be sought after generally by the trade industry or by the department and the practicing professionals, that is the authorized representatives, would be, can I seek an adjournment? Yes, when you are appearing before an appellate tribunal, you may seek an adjournment. All adjournments shall normally be sought before the concerned bench. So you need to appear before the bench and ask for an adjournment, or at least give a letter in writing. And in extraordinary circumstances, the registrar may, if so directed by the appellate tribunal, in the chambers of the bench members, at any time adjourn any matter and lay the same before the appellate tribunal in the chambers itself. Chambers are the chambers of the bench members, and in the chambers itself, you may request for an adjournment. Adjournments contained in multiple legal provisions. So one was contained in Rule 16, then we under Rule 39 of the GSTAT rules, where because the appellate tribunal does not function on any specific day, then the same list of cases will be listed for adjudication, for hearing on another day, right? Will be listed for another day. Say, for example, the appellate tribunal functioned, but a particular bench, say, for example, single member bench was sitting, but the divisional bench was not sitting. There is a particular bench is cancelled for any reason, like inability of any member of the bench. Then as well, the registrar shall adjourn the cases posted for the bench to a convenient date. If the single member bench is not possible, yes, then it would be adjourned. If the division bench did not sit, then it would be, or larger bench, whatever it is, it would be sent to it would be adjourned to that convenient date of the bench. Rule 42 of the GST Appellate Tribunal rules talking also about adjournment when the appellant does not appear. I made an appeal, but I did not appear on the day the date was fixed for hearing. I did not seek an adjournment also. Then what would happen? In such a situation, then the appellate tribunal may, in its discretion, they may themselves decide to dismiss the appeal for default. He did not come, I will dismiss it. Or hear the appeal and decide it on its merits. the departmental representative, say for example, the respondent, not just the departmental representative, just the respondent may place the case and the appellate tribunal may decide the case on its merits. Does not mean the appellant did not come and therefore the case is decided against the appellant. No. Just because the appellant did not come does not mean the decision will be against the appellant. The case may be prima facie dismissed, not to say that the case is decided on merit, but the case is prima facie without even being admitted is being dismissed off because the appellant even did not come. Or they could listen on the merits of the case, and once they have heard on the merits of the case, then the decision has to be based on the merits and not just because the appellant did not come, right? Where the case was dismissed because the appellant did not come for the default of the appellant to appear, then later point in time, the appellant comes forward and says, for these and these reasons, I could not appear on that set date, then the appeal could even be restored once again. For restoration of appeal as well, then there would be an additional fee to the extent of rupees 5,000. Right? Rule 43 of GST Appellate Tribunal rules, this is hearing of appeals ex parte, where the appellant appears and the respondent does not appear. Then the appellate tribunal can hear and decide the case appeal ex parte. Then in which situation they might not really have to wait for the respondent, then they will just carry the case and decide the case ex parte even without the presence of the respondent. Rule 42 where the appellant is absent, Rule 43 where the respondent is absent. Rule 47 talking about actual adjournment. See, because Rule 14 gave the powers for adjournment, Rule 16 gives the powers for adjournment. Rule 47 talks about adjournment. The appellate tribunal may, on such terms as it deems fit, and at any stage of the proceedings, adjourn the hearing of the appeal. Any stage of the proceedings, part of the hearings is done, okay, you may adjourn it. Even without hearing, you can adjourn it. So whatever it is, the appellate tribunal has the power to adjourn the appeal. Now going into a couple of very practical procedures. Rule 18 of the GST Appellate Tribunal rules. An appeal to the Appellate Tribunal shall be filed online. So here again they very clearly specify that it shall be filed online on the GST Appellate Tribunal portal in the form as per the rules and shall contain the following details. In the very title, it shall state in the Goods and Services Tax Appellate Tribunal, and also set out the proceedings or the order of the authority against which it is preferred. In the GST Appellate Tribunal, against the order passed by the Joint Commissioner of Central GST, Coimbatore. So, then the appeal shall be divided into paragraphs and shall be numbered consecutively, and each paragraph shall contain as nearly as may be a separate fact or allegation or point. When you have multiple paragraphs, you have 10 different paragraphs, 10 different facts or 10 different allegations or 10 different legal points. That is how it needs to be generally numbered. The full name, parentage, GSTIN, description of each party and address as applicable shall also be set out at the beginning of the appeal. That is, who is the party, their GST number, and it need not be repeated in each of the subsequent proceedings in the same appeal. Then once you say what is the GST number, what is the name, then we will generally say he is the appellant. He is the appellant. The names of the parties shall be numbered consecutively, and a separate line shall be allotted to the name and description of each party, and these numbers shall not be changed. And in the event of the death of a party during the pendency of the appeal, his legal heirs or representative, as the case may be, if more than one, shall be shown as subnumbers. Say, for example, the appeal is filed against multiple respondents, in which situation, where the respondent even ceases to exist, even if he has died, even on the death of a party, his name will not be removed. His legal heirs will only be shown as subnumbers. So, who is the appellant? If there's only one appellant against 5 respondents. Whatever is it, the 5 respondents, then it would be very, very clear. So, respondent number 1, who is respondent number 2, that will never change during the pendency of the appeal. And that is how the order is also drafted. when you really read any order, then it would very clearly say the appellant has very clearly submitted that respondent number 2. Respondent number 1 might be the Commissioner of Commercial Taxes in the state. Respondent number 2 might be the Joint Commissioner of Central GST. Respondent number 3, the Superintendent of Range ABC. Right? There could be multiple authorities against whom you might be filing an appeal, and therefore every respondent needs to be very clearly numbered. Notwithstanding the number of show cause notices, refund claims or demands, letters or declarations dealt with in the decision or order appealed against, one order issued by the first appellate authority under section 107 or 108, but against multiple show cause notices. 5 show cause notices, only one order has been passed. Then, do I need to file 5 appeals before the GST Appellate Tribunal or only one appeal? It shall suffice for the purposes of these rules that the appellant files one appeal in the prescribed form against the order or the decision of the appellate authority, along with such number of copies thereof as provided in Subrule 21. We will talk about Subrule 21 thereupon in the next session. But so how many copies needs to be presented, whom you should need to give the copies, how the copies needs to be prepared, evidences, how it needs to be prepared. We will discuss everything in detail. But as far as the situation now it goes by, when there are multiple show cause notices, but there is only one appeal by the appellate authority, one appeal order by the appellate authority, then you need to only file one appeal before the GST Appellate Tribunal as is contained in Rule 18, Subrule 2. Rule 18, Subrule 3, where the impugned order in appeal has been passed with reference to more than one order in original. Right? There is more than one order in original. There is only one order in appeal. The prescribed form for appeal filed as per the rules shall be as many as the number of orders in original to which the case relates, insofar as the appellant is concerned. Right? Here, it talks about show cause notice, refunds, demands, then there is only one to one. If there are multiple orders and against which there is only one multiple order in original, only one order in appeal, then you need to file as many number of appeals as is relevant to the original order, right? Because ultimately you are challenging the order in original. Ultimately you are challenging the order in original. In case of an impugned order in respect of more than one person, each aggrieved person will be required to file a separate appeal, and common appeals or joint appeals shall not be entertained. Say, for example, when an appeal order has been made against the company and also its directors, the company has to file a separate appeal, the directors have to file a separate appeal. There cannot be common appeal, there cannot be joint appeals, everything has to be separate appeal. That is also being made very clearly in rule number 18 of the rules. Rule 19, a single rule, very simple. The registrar or the officer authorized by him shall endorse on every form of appeal the date on which it is presented or deemed to have been presented under that rule, and shall sign the endorsement if the appeal is filed manually. So if I am filing a manual appeal, but in all other legal provisions, it very clearly provides that the appeal shall be filed electronically. But here Rule 19 really goes against that to say if at all it is filed manually, then the registrar shall endorse each of it, then it shall be signed also. Rule 20 is the last rule that we will be discussing. Across all the 124 rules, we will not be required to discuss all the rules, but being part 1 of the session today, so within 1 hour, we really wanted to emphasize on a very few part of the rules and then take up the next set of rules for the next sessions. So Rule 20 of the GSTAT rules, contents of an appeal form. Every appeal form shall set forth concisely and under distinct heads the grounds of appeal, and such grounds shall be numbered consecutively and shall be typed in double space of the paper. So the line spacing shall be 2 between each line. Between each line, the line spacing shall be 2. Then under distinct heads, whatever the different grounds of appeal, you are challenging the constitutional validity of the legal provision. Yes, that is separate. You are challenging the violation of principles of natural justice. That is, no opportunity was provided with respect to personal hearing by the adjudicating authority or the appellate authority. So you are challenging the violation of principles of natural justice. Yes, that is a separate ground. You are challenging the service of the notice, then that is a separate ground. You are challenging the limitation of the issuance of the show cause notice or the order thereunder, that is a separate ground. You are challenging the entire proceedings based on invalidity of the DIN number which is quoted in the show cause notice or the DIN number, that is a separate ground. You are challenging the factual accuracy of the details presented in the show cause notice or the order in original or the appellate order, as the case may be, then that is a separate ground. You are substantiating with any of the case laws or the legal interpretation under the GST Act or the rules thereunder, the notification circulars, each of it will be a separate ground. And each of these grounds will have to have a separate heading and it has to be numbered consecutively. Every form of appeal or cross objection or a reference application or a stay application or any other miscellaneous application shall also be typed neatly in double spacing on an A4 size paper, and the same shall be duly paged, indexed, that is paged to say numbered, indexed and tagged firmly with the form of appeal in a separate folder, right? So the procedure of how the appeal form needs to be presented is also very clearly detailed in the GSTAT procedure rules. Every form of appeal or application or cross objection shall be signed and verified by the appellant or the applicant or the respondent or the authorized representative. The appellant or the applicant or respondent or the authorized representative shall certify as true copy the documents produced before the appellate tribunal. When you have produced a copy of the order in original, then the order in original, you might not be able to keep the original order. Then you will say this is a certified copy of the order against which this appeal is being filed. That also needs to be submitted. So these are some of the very broad areas with which we wanted to really kickstart this discussion on the practical aspects relating to the GST Appellate Tribunal. So stay tuned for more sessions in relation to the GST Appellate Tribunal, where we would definitely have part 2 coming very soon in the coming days. So we will definitely upload the video of this part 1 very immediately soon, so that anyone who has missed shall please be informed about this video on YouTube, so that they can really come back to us on part 2 of the session to understand more in detail about the practical aspects of the GST Appellate Tribunal, the procedure rules of drafting an appeal and also appearing. We will be sharing our real life experiences of appearing before the various appellate tribunal, and these experiences would add a substantial value for the discussions going forward. We thank each one of you for your active participation across all these sessions. 73 weeks of Zentax Talks has not been possible without your continued greatest support, and we are highly indebted to you. So we look forward to your participation in Zentax Talk 74 and all the other upcoming sessions. Thank you all for your active participation. Thank you, everyone.